Oscar Pistorius' trial is underway, and we're joined in studio by criminal law expert William Booth to discuss what's happened on day one. Thank you for joining us.
Pleasure.
Now, day one has seen the first witness in the stand. It's Michelle Berger, and she has really been grilled by Barry Rue about what she heard and what she didn't hear. It seems like a seemingly insignificant detail. Why is the defense harping on about this?
Well, I think one has to start by asking, why does the state call this particular witness? And you only call a witness if that witness is going to say something relevant to the trial and is going to assist the prosecution in trying to prove a particular point. Is it because they want to establish intention, the shouting or the screaming? Does that assist the state to prove what they've said throughout from the day he was arrested, that Oscar intended to kill Reva? Or if it's a situation that all she heard was the screams of a male, that could go a long way to establishing that what Oscar is saying, that he thought there was an intruder in his apartment and that he was calling for help. So, it depends from what angle you're looking at that. You've got the cross-examination of his defense counsel on the issue about the screaming, but I think one has to start and ask the prosecution for what reason they're presenting this evidence.
Now, Michelle Berger is a neighbor. She lives in an adjacent estate to Oscar Pistorius' home. Why would the state have called a neighbor as their first witness? Is there some sort of strategy in this?
Well, again, it's not. I think one has to always ask the prosecution. Hopefully they have some sort of plan and why they lead witnesses in a particular order. But because she's called as the first witness doesn't mean to say that it's their strongest witness. There might be a lot of reasons why the prosecuting authorities call witnesses first or in the middle of the trial or right at the end. I would say that you would usually look at starting off well. You want to call your strongest witness right in the beginning, your witness that says as much as possible to try and prove the case against Oscar, the one that can be used and relied on to establish what they are trying to do, and that is to prove that he had the intention to kill her. But there may be other reasons. Maybe she had to be called first because she can't stay around the court too long, or she had to go off somewhere else. But from a strategic point of view, it's not the right way to start off with your weakest witness, or a witness that you feel could be cross-examined and dented as a witness, because that will then set the tone, and the judge will see, well, you're leading these witnesses, they're not making a pretty significant impression on the court. So one would like to bring in your strongest witnesses right up front to knock the defense and to try right from the very beginning establish what they're saying happened, and that was that this was an attack. There may have been an argument, but there was no intruder, and that was a kind of a make-up story after the fact.
Now, this witness took to the stand this morning and carried on all the way to this afternoon. Is that typical? Can we expect to see one witness per day?
Again, it depends what the witness says. The length of cross-examination will always depend on how much the witness has to say. On the other hand, effective cross-examination doesn't mean you have to take days and days with a witness. Sometimes it's those critical questions that are asked that can knock a witness right up front at the very beginning of that witness's testimony and rattle the witness. So if a witness comes and spends 4 hours giving his or her evidence in chief, that is evidence when the prosecution is leading the witness, then the defense may need to spend that amount of time or even longer. But you might have a witness that comes to say very little, a formal witness, maybe somebody who has very little to do with actually proving the guilt, but is necessary in the chain of evidence to try and establish certain aspects of the case on behalf of the prosecution.